We are going to cover the Bryan Kohberger hearing on delay. It was a few days ago. I haven't watched it yet. We're going to go over the court filings first, and then we will go to the hearing. All of the lawyers appear via Zoom, so we will cover all of the documents that lead up to it and then go from there. But this is all regarding restitution. And for those of you being like, but didn't Bryan Kohberger take a plea deal? He did take a plea deal, and that plea deal involved restitution. And there are a number of motions that we need to go through to take a look at why the conversation about restitution is coming up anew. For those of you who will inevitably ask the intelligent question because the law nerds are bae, you're going to say, but what if he can't pay? If he can't pay, then he can't pay. However, if he has any money come in, if he decides to sell photos from his childhood in connection with an interview, because media doesn't pay for interviews, but they'll pay to use your photos, that money can go to the Secretary of State and then pay restitution first. So there are ways that any money he has coming in can be redistributed. Let's take a look at the docket. This was filed August 27th, 2025, stipulation regarding restitution. The prosecutors are agreeing with the defendant the amount of restitution here, which is going to come up as we look at why is there a restitution hearing if it was stipulated. The Crime Victims Compensation Program, $14,393.13. Jim and Stacy Chapin, $5,720.72. Jeff Kirk Kernodle, $8,843.03 for a total of $28,956.88. So that is the stipulation, the agreed upon restitution. Let's take a look at what the state is asking for in attempting to reopen the question of restitution after a stipulation, which is unusual to me because they agreed. So everything should already be done. From September 22nd, 2025, state's request for restitution and motion to seal exhibit. Comes now the state of Idaho by and through Latah County prosecuting attorney and respectfully moves the court for orders of restitution herein against the defendant and in favor of Steve and Christy Gonsalves in the amount of $20,000 and in favor of Karen Laramie in the amount of $6,920. So the first thing that stands out to me is that these two families were not included in the prior restitution stipulation. The defense then objects. I don't blame the defense for that when there's been an agreement. Like, we already stipulated, and the stipulation didn't say further restitution may be requested, further restitution may be required. It doesn't indicate in any way that that stipulation was not complete and total. And sometimes that happens where you stipulate and say, we stipulate to this amount, there is additional restitution coming. This is from October 7th, 2025. Comes now Bryan Kohberger by and through his attorneys and objects to the state's request for additional restitution filed September 22nd. The grounds for objection are that 1, the plea agreement specified funeral expenses and funds reimbursed through Idaho Crime Victims Compensation Fund in an amount to be determined within 60 days from July 23rd, 2025. Mr. Kohberger stipulated to those amounts, resulting in court orders in the amount of $28,956.88 on August 29th, 2025. 2, the additional funds sought do not qualify as an economic loss under the Idaho Code because Steve and Christy Gonsalves and Karen Laramie received extensive funds through multiple GoFundMe campaigns that specifically asked for and covered the expenses sought. I'll be interested if that disqualifies the restitution. I don't think that having a GoFundMe would disqualify the restitution. 3, Mr. Kohberger has no ability to pay now or in the future to pay restitution because he is serving 4 consecutive life sentences plus 10 years. That's not going to change anything. The state respectfully responds to the, quote, defendant's objection to the state's request for additional restitution filed October 7th, and the state acknowledges the Rule 11 plea agreement filed herein regarding restitution under Section 4 of the agreement states. The state may seek restitution orders regarding funeral expenses and crime victim compensation reimbursement in an amount to be determined. At the time of the plea agreement, the state was under the impression certain expenses incurred by the victims' families would be covered by the crime victims' compensation. After the sentencing hearing, the state was informed that crime victims' compensation will not cover travel and lodging expenses for attendance of court proceedings. That explains why they languaged, maybe overconfidently, the plea agreement the way that they did. They languaged the plea agreement because they believed that the families would be covered by crime victims' compensation, and then crime victims' compensation would be compensated. They go on to say, on behalf of the victims, the state submits an itemization of expenses that were incurred by the victim's family, including expenses not covered by the crime victims' compensation for the court's consideration. But the plea agreement says funeral cost and crime victims compensation, and this is not funeral cost, and this is not crime victim compensation. It would have, I think, been covered under the law. The law says expenses. If they had put another line in the agreement that said expenses, it would have been in there. Leonard, you know that I love a sponsor that makes things easy, and one of the most frustrating things to deal with is having your identifying information and your personal information out on the internet. Thankfully, Incogni makes it easy to get that information removed. Leonard, in October, did you see the headlines about 183 million email passwords being exposed? Well, in early November, there is new reporting showing that that's actually not the case, and it was 1.3 billion unique email passwords that were exposed in what is the largest corpus of data some cyber experts have ever seen. It is not an understatement that your data is probably out there in a way that you don't want it to be, which is why we are talking about one of my favorite services, today's sponsor, Incogni. Not only do they do data removal, but they also have custom data removal where you can request data be removed from specific places. It is time to add this to the list of things that modern life requires, and making sure that your data is being removed off the internet is one of those things. So Leonard, if you are ready to take back your data, you can do it with Incogni at a great discount at incogni.com/Emily to get 60% off annual plans. So just head to incogni.com/Emily and use code Emily to get 60% off annual plans. Let's get back to today's episode.
In response to the defense's objection, the state has modified or adjusted our position on the restitution. We are, pursuant to the plea agreement, seeking restitution for the funeral-related expenses, which are the urns that are described in Exhibit 2.
So they were originally seeking more than $20,000 for the Gonsalves family and more than $6,000 for Karen Laramie. And under $2,000 per family is for the urns, which are the funeral expenses. So are you telling me that you have now gone from asking for $20,000 to asking for just under $2,000 for each family?
To our response, we are not affirmatively advocating for the travel expenses and lodging expenses of the family because we do not believe that we can legally advocate for those. At the same time, the families provided those to us, and we want to provide them to the court and counsel just so everybody was aware that they are there. But we are not arguing affirmatively for that because of the wording of the plea agreement itself. So
No. Because of your mistake.
What the state is actually requesting today is just additional restitution for the funeral-related expenses, which are the urns for the families.
There's no way that Mr. Kohberger is ever going to profit from any sort of movie or book because Idaho Code 195301 specifically precludes that.
Well, I don't think that does. That is not what I interpret the law to be. I'm going to let the judge interpret it, though. Me, not an Idaho attorney.
Specifically precludes that.
Well, it precludes, it allows that monies are swept from his account for those income to pay certain things.
Yes.
If those certain things, if there's no debt for those certain things, then
he gets it.
Does the money not go then to the defendant?
Yes, it does. If there's $50,000 in restitution ordered and a defendant makes $100,000, the $50,000 in restitution gets paid, the balance of it goes to the defendant.
What harm is it to order the restitution, which would then sort of jump in line in terms of priority of payments over some of the other ordered payments, such that if Mr. Kohberger does receive money into his accounts from any source, that he's then that those monies are then put to that use. Certainly, we're not worried about Mr. Kohberger's credit rating with having debts at this point. I'm not sure what the concern would be to, given the uniqueness of this case and the potential for family members, et cetera, to earn money from it, and potentially we've seen members of the public send money to Mr. Kohberger, is my understanding, to his books. What's the downside to ensuring that the victims are as whole as possible from this by ordering the restitution, which again would jump in line from some of the other court-ordered fines, et cetera? And if the money's there, it's there. If it's not, it's not.
Judge, I don't see that Idaho Code or Idaho law asks the court to make an analysis on the downside, but whether or not there is foreseeability of payment. And all of the things that you just listed are pure speculation. There is no book or movie that's in the works by any of his family, and to say that those things are going to happen is absolutely speculative, and there's nothing to substantiate those sorts of assertions happening in the future. So
well, there's a history in the 3 years he was incarcerated of him receiving 5 figures put on his books. Doesn't that give the court some history to suggest that such contributions from whatever source may continue into the future?
As I stated earlier, Judge, that was at a different time in the case. That was at a time when, he had not entered a plea. He was not deemed convicted of the crime. The money, a lot of that money was coming from his family to be able to have communications with their son and brother. And to speculate that those types of dollars are going to be able to happen for the next many decades is exactly that. It's pure speculation, not based on something that is foreseeable or based in something that's in fact before this court. It's another factor that the court actually can look at under 1953-04 subsection 7 is other factors, and those factors that factors that the court deems appropriate, and that can be collateral resources that the families obtained over $200,000, which
you're arguing collateral resources from the GoFundMe for their murdered children when the state has already said all they're seeking is the compensation on the urns. Counsel, you're not looking at the judge's face while you're making this argument. I'm excited to see what the judge's face is going to continue to do.
Definitely reimburse the cost of the urns in terms of
the GoFundMe has reimbursed the cost of the urns.
Which definitely reimburse the cost of the urns in terms of economic costs.
I also want to turn to the plea agreement because the
court's like, yeah, no.
A reasonable interpretation of the plea agreement that the defendant will not contest the state's seeking of restitution that is outlined in the plea agreement. Otherwise, why would it need to be in the plea agreement? It seems to me it's the plea agreement. A reasonable interpretation is the defendant is agreeing to pay restitution for those items that are identified in the plea agreement, which includes victims' compensation. Which includes in this case funeral expenses.
The judge is like, but isn't part of your plea agreement that you're not going to fight this, counsel? You're treading on some dangerous ground, counsel. Because if part of the plea agreement is that you will not contest it, you trying to violate your plea agreement? Counsel, I don't think that's what you want to do.
So You took advantage of the plea agreement to get the benefit of the bargain regarding the state's dropping of the death penalty. Why should you not be held to the plea agreement to pay the victims the costs of interning their children?
Judge, I believe that our pleading was clear, that we understood that urns fell underneath a funeral cost, but that once we have a hearing on this matter, that doesn't eliminate the court's duty under 1953-04 to do the ability to pay analysis.
Disagree.
And that's why.
Well, are you in violation of the plea agreement by arguing that your client shouldn't have to pay those?
Oh boy.
We are not in violation of the plea agreement. If there was any violation of the plea agreement that took place, it's the state seeking this when the other expenses, when it was clear under statute and under the Idaho Victims Compensation rules that those were not reimbursable expenses.
Oh boy.
But they've effectively withdrawn those requests and are seeking what's outlined in the plea agreement. What's the point of the plea agreement on restitution if the defense is able to argue against the restitution called for in the plea agreement itself?
So let's talk about the hearing in Idaho from November 5th. The prosecution asked for additional restitution and then started the hearing with, we are withdrawing our request for everything except the amount of the urns. The restitution agreement is very specific. It says funeral expenses and things that were reimbursed by the state victim compensation fund, essentially. And the travel expenses, the prosecutor said, we found out after the plea that those would not be compensated. So under the way we wrote the plea agreement, we can't ask for that. So the prosecution is saying that is completely our bad. We messed up on that. That was not our understanding. We thought we had it right. We didn't. It could have been fixed at the plea agreement. And the court said, but I can't fix it now because you made an agreement and you're being held to that agreement. And the prosecution said, you're absolutely right. We're only asking for the urns. And then the defense, instead of saying, we agree to the urns, we didn't agree to the rest, it was withdrawn, we have nothing more to say, the defense decided to continue arguing that the court needed to make a finding that the defendant should be required to pay the restitution. And the court was not having it at all. The court said, but you agreed. You took the benefit of the bargain. If we're looking at contract law, and you argued contract law, if we're looking at contract law, the benefit of the bargain is that the death penalty came off the table. You agreed to pay restitution. This is just another category of appropriate restitution for funeral expenses. Why are you arguing? And the defense said, well, we still need the court to make a determination that it's appropriate restitution and the defendant has the ability to pay the restitution. And the court's like, are you violating your plea agreement in making this argument? And the defense said, no, I'm not violating the plea agreement. The prosecution was violating the plea agreement by even asking for those additional amounts. And the court said, bro, I'm summarizing, they withdrew it and admitted that that was their error. And yet you're still arguing. The court was not happy with the defense arguments about Kohberger's ability to pay and whether this was appropriate and whether the court should order Kohberger to pay the restitution, which the court is clearly inclined to do. My only question is how much, but the court is clearly inclined to order Kohberger to pay for the urns for the additional victims that were not put in the agreement before. So when we get to the end of the day on this, I think that the court is going to say these additional funds are getting paid. You're going to pay them. And that he has the ability to pay. But the judge kind of spilled the tea on some of the stuff that was under seal as attachments in these arguments, which was how much the defendant had put on his books. And the court said he has had at least 5 figures worth of money, over $10,000. So potentially tens of thousands of dollars put onto his books during the time that he was pending trial. And the defense was arguing, but that's changed now that he's pled. It's a different situation. A lot of that money was from family, and it's a different situation now. He doesn't have the ability to pay. And the defense argued he can't earn money from selling his story or talking about this case or anything like that. And the court said, no, I disagree. I do not think that that's what the statute said. I agree with the court's interpretation. The interpretation of the statute in Idaho regarding whether defendants can essentially profit from discussing the crimes that they are convicted of is that the money gets diverted to pay back restitution and restitution judgments first. And then any money that is left over, if any, goes to the defendant. It's not that they can't earn it, it's that it pays off restitution before they get it. And what we learned from the defense attorney, which answered a question that I had, was that 20% of any monies put onto the defendant's books do get diverted to start paying those restitution orders so that the restitution will get paid to the victims first, then to the crime victims compensation fund, then to the court orders. So that 20% will make sure that the victims get paid first. It might be slow, but if he lives a long life in prison, then they might see that they get compensated for what has been ordered, which is funeral expenses, and then reimbursement to the victims' compensation fund. Now, if the victim's family chooses to fight with the state victims' compensation fund, I don't know if that's going to be like trying to fight with insurance to cover something they say they're not covering. I don't know. I don't know if the families will choose to say to the victim compensation fund, no, we were told you would reimburse our travel expenses, reimburse our travel expenses. They might choose not to do that because it does seem that they received money from GoFundMes. That money shouldn't make the defendant off the hook for restitution. But the way that the prosecution wrote the restitution order cuts out all of those travel expenses. But that's on the error of the prosecution, not because of GoFundMe amounts received. And the court was very much like, hey, be mindful of these arguments, because are you going to violate your plea agreement? And the prosecution did not say, well, the defense is violating their plea agreement, you should withdraw the plea agreement, Your Honor. I don't think the prosecution's going to argue that. I don't think they want to gear this case back up for trial, because if the defendant violates their plea agreement, it just turns around and it all goes to trial. And that's not what the court asked for. That's not what the prosecution asked for. But the judge warned the defense pretty sternly that you're treading into some potentially uncomfortable territory here. Knock it off. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerd.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a Law Nerd.